The tractor was sitting in the yard when the bank officer arrived. It was a 1980 model, a large frame four-wheel drive machine that Glenn Hartley had purchased in August 1982 from a farm equipment dealer in Vermilion County, Illinois. Glenn had paid $38,500 in cash. No note, no financing. He had been saving for 2 years, setting money aside from good harvests, and he had walked into the dealer's showroom with a certified check and walked out with the tractor. He had been using it for 4 years without incident. It had planted corn, pulled the disc, run the grain cart. It was the most productive piece of equipment on the farm. When Glenn's agricultural lender requested a current equipment list as part of a routine loan review in the spring of 1986, Glenn had listed the tractor at the top, 1980 model, purchased August 1982. Cash, no encumbrance. The bank officer who arrived to conduct the collateral inspection handed Glenn a printout from a UCC search. The tractor was listed under an active financing statement. The secured party was a commercial lender in Decatur, the institution that had provided floor plan financing to the equipment dealer from whom Glenn had purchased the machine. Glenn held up the bill of sale. The bank officer looked at it and said, "That's a receipt. It's not a lien release." The tractor had a lien on it from the day Glenn drove it off the lot. He had simply not known. Glenn had been farming in Vermilion County since 1974. He rented 320 acres from 2 landlords and owned 80 acres he had purchased in 1979, a modest but functional operation that grew corn and soybeans on the flat ground east of Danville. He was a careful operator. He kept his equipment maintained, paid his operating line down each fall, and had not carried a balance into the new year since 1977. The tractor purchase in 1982 was the largest single equipment expenditure of his farming career. His existing tractor, a 1971 model, had reached the point where repair costs were consuming more time and money than the machine's reliability justified. He had been watching the used equipment market and had identified the 1980 model at a dealer in the county seat as a good value, lower hours than comparable machines at auction, priced at $38,500, which was below what he had seen similar equipment bring at recent estate sales. The dealer was a family operation that had been selling farm equipment in Vermilion County for 23 years. Glenn had bought a planter from them in 1978 and a grain wagon in 1980. The relationship was familiar. He did not think of the purchase as a transaction requiring particular legal scrutiny. He examined the machine, test ran it, agreed on the price, and wrote the check. The dealer provided a bill of sale on dealership letterhead, date, description, price, payment method in cash, and the dealer's signature. Glenn filed it with his other farm documents. What neither Glenn nor the dealer discussed at the transaction was the financing arrangement that the dealership maintained with its equipment inventory. Equipment dealers do not typically own their inventory outright. A dealership that carries a floor of 40 or 50 tractors, combines, and implements cannot purchase all of them with cash. Instead, dealers use floor plan financing, a revolving credit facility provided by a commercial lender or manufacturer's finance arm that allows the dealer to take possession of inventory while the lender retains a security interest in the machines until they are sold. The dealer pays interest on the floor plan balance. When a machine is sold to a retail customer, The dealer is obligated to apply a portion of the sale proceeds to pay off the floor plan note on that specific unit, and the lender is obligated to file a UCC termination statement releasing the lien. In August 1982, the Vermilion County dealer had a floor plan facility with a commercial lender in Decatur. The 1980 tractor that Glenn purchased was among the machines covered by that facility. When the dealer had taken delivery of the tractor from the manufacturer, the lender had filed a UCC financing statement identifying the machine as collateral, a recorded claim in the Illinois Secretary of State's UCC database that put the world on notice of the lender's security interest. When Glenn paid $38,500 and drove the tractor off the lot, the dealer was obligated to pay down the floor plan note on that unit, and the lender was obligated to file a termination statement releasing the lien. The dealer deposited Glenn's check. The floor plan note on the tractor was reduced. The termination statement was never filed. Whether the oversight was administrative error, financial distress, or something else in the dealer's operations at the time was not something Glenn could have known. The dealer had been in business for 23 years, but 1982 was a difficult year for agricultural equipment dealers. The farm crisis was compressing margins across the dealer network as farmers bought less and traded in more. Whatever the reason, the release that should have removed the lien from the UCC record did not appear. The lien stayed on file. It was still there 4 years later when Glenn's bank ran the search. The bank officer who conducted the 1986 collateral inspection was methodical. As part of the lender's annual review process, he ran UCC searches on each piece of equipment Glenn had listed as unencumbered collateral. The searches checked the Illinois Secretary of State's UCC database for any active financing statements covering the listed serial numbers. The 1980 tractor came back with a hit. The financing statement had been filed by the Decatur lender against the dealer as debtor, a standard floor plan filing that listed the dealer's inventory as collateral, including specific serial numbers. The tractor's serial number was in the filing. The statement was active. No termination had been recorded against it. The bank officer explained the finding to Glenn. From the bank's perspective, the tractor carried an active lien from a prior secured creditor. That lien, if valid, would be senior to any security interest the bank might take in the equipment. A lender considering the tractor as collateral had to evaluate it as encumbered property, not free and clear property. The value the bank could assign to the tractor in Glenn's collateral package was significantly diminished. Glenn produced the 1982 bill of sale and explained the purchase. He had paid cash. The machine was his. The bank officer acknowledged the bill of sale. He explained that the bill of sale established that Glenn had paid the dealer for the tractor. It did not establish that the dealer's lender had released its security interest. Those were two separate events. The first had occurred. The second had not been recorded. Glenn asked what the lien meant practically. The bank officer told him that until the lien was cleared from the UCC record, the tractor could not be used as unencumbered collateral. If Glenn needed to refinance or expand his operating line, and the tractor was needed to support the loan, the lien was a problem. If Glenn ever tried to sell the tractor, a buyer's lender would find the same lien, and the sale would be complicated in the same way. Glenn hired an attorney in Danville named Walter Frisk, who handled agricultural and commercial matters in Vermilion County. Frisk reviewed the UCC filing and the 1982 bill of sale and mapped out the resolution path. The Vermilion County equipment dealer had closed in 1984. The farm equipment market had not recovered, and the family had wound down the business. The dealership assets had been assigned to a receiver when it closed. The commercial lender in Decatur that held the floor plan facility had worked through the dealership's obligations in the receivership process. Frisk contacted the Decatur lender to explain the situation. A retail customer had purchased a machine from the dealer in 1982, paid cash, and the lender had never filed a termination statement on the floor plan filing covering that unit. The lien appeared active in the UCC database, but the underlying debt had been satisfied by the retail sale proceeds 4 years earlier. The Decatur lender's records were consistent with Frisk's account. The floor plan note on the specific tractor had been marked paid in August 1982, the same month Glenn had purchased it, but the termination statement had not been filed. Whether the filing had been overlooked or had fallen through a gap in the administrative process during the dealership's eventual difficulties was unclear from the 4-year-old records. The lender agreed to file a UCC-3 termination statement against the financing statement covering the tractor's serial number. The termination was filed in July 1986 and recorded in the Illinois Secretary of State's database within 10 days. The lien was cleared. Glenn paid Frisk $740 in legal fees for the research and correspondence. He had purchased the tractor for $38,500 in cash in August 1982. He had used it for 4 years without incident. The lien had been on the UCC record the entire time. Not because anyone had tried to claim the tractor, but because a termination statement that should have been filed in 1982 had not been filed. The Decatur lender had not been asserting the lien. It had been a dormant record, accurately reflecting a filing that had never been formally closed. No one had come for the tractor. No one had tried to repossess it, but the record was there, and when Glenn's bank ran the search in 1986, the record was what the bank saw. To understand why Glenn's bill of sale had not protected him from the UCC lien, it helps to understand how dealer floor plan financing works and what happens, or is supposed to happen, when a retail sale occurs. When a dealer takes inventory from a manufacturer or distributor, the floor plan lender files a UCC financing statement covering that inventory. The filing is in the dealer's name, and it covers the specific machines identified by serial number. This filing is a public record, visible to anyone who searches the UCC database under the dealer's name or under the serial numbers of the covered machines. When a retail customer purchases a machine, the intended sequence is customer pays dealer, dealer pays floor plan lender, floor plan lender files a UCC-3 termination statement releasing the lien on that specific serial number. The termination is the mechanism by which the public record is updated to reflect that the security interest in the sold machine has been extinguished. The buyer in ordinary course of business rule provides a protection for retail buyers that partially addresses this risk. Under UCC Article 9, a buyer who purchases goods from a merchant in the ordinary course of the merchant's business, meaning a standard retail sale, takes the goods free of security interest created by the merchant, even if the security interest has been perfected. This rule is designed to protect retail buyers from having to investigate the dealer's financing arrangements before every purchase. The buyer in ordinary course protection is real and significant. In Glenn's situation, it meant that the Decatur lender's floor plan lien did not follow the tractor into Glenn's hands as a valid claim the lender could enforce against Glenn. The lender couldn't repossess the tractor from Glenn on the basis of the floor plan filing. Glenn's ownership was not threatened by the lien in terms of direct enforcement. What the lien did affect was Glenn's ability to use the tractor as collateral for his own financing. A lender evaluating the tractor as collateral runs a UCC search. The search returns the active financing statement. The lender sees a recorded lien and treats the equipment as encumbered, not because the lien is legally enforceable against Glenn, but because the record shows a claim, and the lender cannot know from the record alone whether the claim has been released. Until the termination statement appears in the database, the record is ambiguous to any third party who searches it. The receipt and bill of sale that Glenn had were evidence of his transaction with the dealer. They were not UCC filings. They did not appear in the database. They did not update the record that existed against the serial number. From the perspective of anyone searching the UCC system, Glenn's bank, a potential buyer's bank, any lender evaluating the machine as collateral, the active financing statement was the controlling record. The public record does not know what you paid. It knows what has been filed. A receipt is evidence of a transaction. A termination statement is evidence of a release. They are not the same document. Glenn's 1986 refinancing proceeded after the termination statement was filed and recorded. The tractor was added back to his collateral schedule as unencumbered equipment, supporting the loan amount he needed for that year's operating season. He had owned the tractor for 4 years. The lien had been on the record for 4 years. No one had acted on it. No one had tried to take the machine. The Decatur lender had no interest in pursuing a retail customer who had purchased in good faith from the dealer. They had their money from the floor plan payoff in 1982. The lien had been a record problem, not an enforcement problem. But record problems become practical problems. When a bank runs a search and makes a collateral decision based on what the record says. The record had said encumbered. The tractor had been encumbered on paper since August 1982. Glenn had paid cash for it. He had driven it off the lot. He had farmed with it for 4 years. He had not known he needed a termination statement as well as a receipt. Cash bought the machine. Only the release bought it free and clear.